Good afternoon. This is attorney Elise Gross with the Presser Law Firm. Welcome to today's webinar. Today we're going to be talking about LLCs for asset protection. If you have any questions during the course of the webinar, you can type them in the chat box, and if I'm able to, I'll be happy to answer them. If they're too complicated or too long an answer, then I will tell you that we will send you a response via email. And if you're interested in what we're talking about today or in any other topics on asset protection or estate planning, we always welcome you to call or contact the firm. You can contact us at info@assetprotectionattorneys.com, and we can always set up a preliminary complimentary consultation for you. In addition, we are having a webinar each month, and we alternate between estate planning and asset protection topics. We also have a weekly e-newsletter if you're not already receiving that. We would love to have you receive it. So please let us know. And again, any contact would be info@assetprotectionattorneys.com. I've been an attorney for over 25 years in South Florida, practicing in the areas of asset protection, estate planning, and probate. Today, we're going to be speaking about the LLC specifically. We'll touch a little bit upon some other stuff with regard to asset protection, but mostly we'll be focusing today on the LLC. A basic overview of what we're going to be talking about today. After we define asset protection, we'll talk about what the LLC actually is, both the advantages and the disadvantages, when you should use it over other types of entities, specifically what types of assets would it be appropriate to use an LLC for. We'll go into the operating agreement a bit, how you dissolve the LLC, and different jurisdictions that you might consider using, or more likely we'll really be discussing how do you choose the appropriate jurisdiction. So what is asset protection? The basic definition as we define it is the legal process of titling both your personal and business assets to put them beyond the reach of future potential threats, creditors, and liabilities, while at the same time enjoying the benefits of those assets. So it means you want to do a proactive approach to asset protection. You don't want to protect your assets, or at least attempt to protect your assets, after you already have a creditor coming after you, because then your options are going to be somewhat limited. It doesn't mean you can't put some sort of barrier in between the process of collection and the creditor, but if you're doing it too late, then it's more than likely that a judge is going to see it as a fraudulent transfer, and you're likely to lose that asset anyway. You could still make life difficult for the creditor. You may still be able to negotiate a better settlement, but if you're acting proactively, you're in much better shape and your options are much greater at that point. In addition, when you do asset protection, you want to make sure, and this is what we're going to be focusing on today, how do you title those assets? How do you own them where you can still control them and still enjoy the benefits of them? When you're being pursued by a creditor, if they have a judgment against you, the last thing you want to do is what we call be the low-hanging fruit. If there's a series of potential defendants who have judgments against them, you don't want to be the one that stands out because your assets are readily available for a creditor to seize. You want to be the one that they say is on the near impossible list, and they're going to go after somebody else. So you never want to be the low-hanging fruit, and you never want your assets to be considered low-hanging fruit. So what does that mean? If you think of your list of assets as a tree and you hang them on branches, you hang each asset on a branch. Well, obviously those that are exempt on their own through state or federal law, those are going to be on the high part of the tree because nobody will be able to get at them, or at least it'll be very difficult. But a bank account that you keep in your own name, well, that's low-hanging fruit. And then there's everything else in between. So you may want to have one or two small assets that somebody can get to so that they feel like they can actually get at something, but certainly nothing of substance because you want to be as creditor-proof as possible. Again, the ultimate goal for making your assets protected is not that you're never going to pay a creditor, because most people do not want to live with a judgment hanging over their heads, but that when you do a settlement, you're going to settle for pennies on the dollar and for as little as possible. So what are the advantages of an LLC? Well, first of all, let me just kind of define what an LLC is. It's a limited liability company, which means it is a company that is created, it's formed in whatever jurisdiction you're going to form it in, and it's an official created company. The limited liability aspect of it is that under LLC law, the owners, who are considered the members of the LLC, and the managers, if it's a manager-managed LLC, do not have personal liability for the company and for acts of the company or liabilities of the company. So in simplicity, let's say the LLC had borrowed money and there were no personal guarantees on it, then the members and managers would not have personal liability and would not be required to pay off that loan if the loan went into default. In addition to that, if you use real estate as an example, if there's a piece of property owned by the LLC and neither the members nor the managers did anything negligent to cause a problem, and someone is hurt and they sue the LLC, and they can get the asset inside the LLC, but they wouldn't be able to reach the members or the managers personally and go after their individual assets. This is what we call inside-out protection. It means from the inside, the managers and members are protected from liability for the debts and issues of the company. From a tax perspective, the LLC is pass-through. So it works similar to an S-Corp. There's no double taxation. When you have an interest in an LLC, you can either elect to, if it's a multi-member LLC, you can elect to treat the LLC as an S-Corp, which some CPAs decide to do, in which case the membership interests are treated as if they're shareholder interests, and the dividends or the distributions, as we call them with LLCs, are passed through to the individual members, but the LLC would not pay tax on its own. You can also have the LLC, where it's multi-member, be treated as a partnership, which is the default, in which case, again, it would pass through based on proportion to the individual members and not be taxed in itself inside the LLC. If it's a single member LLC, then it's generally passed through to its single owner and may not even file a tax return, but even the single member LLC can elect, if the CPA so chooses, to be treated as an S-Corp. And it's beyond the scope of today's webinar, but there are reasons, advantages and disadvantages to the S-Corp election. So what are some of the disadvantages of the LLC? Well, number one, unlike a corporation, you can never go public with that corporation, with that LLC, which means that your potential for high value of the company is limited. We've all seen incredible stories where a small company, starts out as a mom and pop and all of a sudden goes public and the shares are astronomical in price and people make tons and tons of money. An LLC can't do this. Now, an LLC can potentially convert to a corporation at a later date if it so chooses, but if you do that, you are potentially losing some of the benefits of the LLC. In an LLC, is often an additional tax because an owner of an LLC who's also employed by the company, it's a guaranteed payment. So there might be a surcharge on that and paying unemployment taxes. So you have to be careful with that. Bottom line is when you're forming a company, you have to make a decision with your attorney, with your CPA, based on what you're actually going to be doing, who's going to be employed, as to what the proper corporate structure is going to be. Is it a corporation? Is it an LLC? Is it a C Corp? Is it an S Corp? Is it a partnership? There's many different options. So when you're evaluating, you really want to look at the big picture before you make that decision. And the LLC is not always a possibility. So for instance, and I believe there's another slide on this, if you're a professional and you want to set up a company, not every state allows for what we call a professional limited liability company or a PLLC. So you may not have the LLC option available for you, and then you may have to do either a PA or some sort of corporation. And then depending on what jurisdiction you're in, you may not have the full advantage of an LLC, what we call outside-in protection, which means you as the member, as an owner of the LLC, can a creditor take against you personally, take your interest in the LLC and take your membership. And that is something we're going to be talking about further. So why use the LLC over other entities? Well, we talked a little bit about the corporation versus the LLC. In a corporation, if you own your corporate shares, then if you get sued and get a judgment against you, a creditor can actually take your corporate shares. They can seize it just like they could take your shares in Facebook or IBM or Amazon or whatever else you have. Whereas with an LLC, if you have what's called charging order protection against you in that state, they can't foreclose on your interest. So that LLC asset would be safe from your individual creditors. In addition, the LLC is often much simpler. It doesn't require as many of the corporate formalities as you would with a C or an S Corp. It doesn't have the filings for a tax return if it's not being taxed as a partnership or as an S Corp. So there's a lot of things that an LLC might have that a corporation may not. You can also have a partnership. If you have a general partnership, then all partners are going to be liable for everything. So the LLC certainly has an advantage over that. And there are different hybrids of the partnership, again, beyond the scope of today, but there are different hybrids of partnerships which are kind of a cross between a partnership and an LLC. There are a double LP and a triple LP. Those might afford you similar protections as we have inside the LLC. I also think that at this point, I'm going to mention, and then I'll take it up again when we talk about specific assets, having a land trust. I've been hearing a lot from people, why not have a land trust when you're going to own property? Well, the land trust has certain advantages, which I'll go into when we talk about real property, but it's not really the entity that you're going to use for anything other than potentially for real property. So what can the LLC protect? Well, technically it could really protect anything. It could be an operating company if you so choose, but where the LLC is mostly used is for assets that have potential to cause liability. So for instance, if I own a piece of property, if someone slips and falls on the property, so somebody gets hurt, if the property falls down and stuff is damaged or people are hurt from that, if there's mold or there's some sort of toxin and there's nothing that you personally did that was negligent, if you owned that property in your own name, then if the person who was hurt got a judgment against you, they would be able to sue you personally. And not only would they be able to take the value of that property, they could sue you for everything that you own personally. So they'd be able to get at you. If you put that property instead in an LLC, then if something happens on the property, and again, not caused by your personal negligence, then yes, that creditor would be able to they'd get a judgment against the LLC. They'd probably be able to get the asset inside the LLC, which would be the house, but they wouldn't be able to get at you, the member, or you, the manager, personally. So your other assets would be safe. Commercial real estate is an excellent example because commercial real estate is generally used for rental, whether it's your business that rents it or there's multiple renters in the property. It's usually a much higher valued property than a home. And if you have the property inside the LLC, then the LLC acts as the landlord, not you personally. The LLC gets its own insurance, and the LLC protects you from the claims that other occupants or people that were hurt will make against the LLC. And again, those creditors might be able to get the property in the LLC, but they wouldn't be able to get at you personally. So now that we know about the real estate end, what we need to point out here is that it doesn't make sense in most cases to put multiple properties in one LLC. So why do I say that? Well, I've already told you that if somebody gets a judgment because something happened on the property and they get a judgment against the LLC, while they can't get at you personally, they can get at the assets of the LLC. So if you had two pieces of property inside one LLC, then that creditor who was injured on property A could now potentially also get property B. Whereas if you had property A in one LLC and property B in the second LLC, A's problems are insulated from B, B's problems are insulated from A. We see a lot of people who come through here who have many different properties, and they always ask the question about this, and we always explain to them how the liability can affect one property versus the other. And then we always say to them, while we firmly believe that every property should be separately owned in a separate LLC, many times you have to look at a cost-benefit analysis as to what works for you. And if it's too costly, because there are upkeep charges with LLCs, if it's too costly to have each property owned in an individual LLC, then knowing the risks, you can decide maybe on an actual value allocation as to what you want to put inside in one company and then move on to doing a second one. For instance, if you own Section 8 properties, when you were able to get them, depending on where you're buying them, for $50,000 or $70,000 a piece, maybe you don't do a separate one for each one, although we've had many clients who do it. Maybe you combine 3 properties and have a $200,000 or $250,000 cap of value of net worth in each LLC, and then you start building on another one. I've seen it both ways. Obviously, the best advice is separate out, not too many eggs in one basket. But if you're going to have to combine, then at least do it with a logical reason behind it. And certainly, you have to balance out cost-benefit analysis here. Real property could also be owned inside of a land trust. We're not huge fans of the land trust because it's a revocable instrument. And if it's a revocable trust, then there's not real asset protection to the person who created the trust. And while it has some degree of privacy to it, most of the times anyone can find anything out about anything. So I wouldn't say privacy is really a big factor on the land trust because the trustee of the land trust is visible on the public records because of the deed. So you're going to see that anyway. If you are going to do a land trust, then I would suggest that you at least have the beneficiary be an LLC so that at least there's some protection for the beneficiary. And if the property was ever sold and distributed, it doesn't get distributed to an individual beneficiary. It gets distributed to an LLC, and therefore you have at least a little bit of asset protection to it. Land trust laws are only actually officially in about 6 states, which does include Florida, but other trust laws will apply if you are not in a state where there are specific land trust statutes. Okay, so, oh, sorry, okay. I forgot to talk about equipment and other assets. So, and boats and planes. So we always ask the client, do they have any toys? Do they have any planes, fancy cars, boats, jet skis, any sort of stuff that people are driving that can cause accidents and there'd be liability. With the understanding that if you're the one operating whatever this vehicle is, and there's a problem, they're going to sue you personally because you were the operator. But they're also going to sue the owner. So if you owned a boat and you weren't the one navigating the boat, you maybe weren't even on the boat, then whoever is driving the boat will be sued if there's a problem, and you'll be sued because you own the boat. Whereas if you have an LLC that owns the boat and you're not the one navigating the boat and you haven't done anything negligent to create the problem, then a judgment creditor, the person who got hurt, will sue the LLC, may be able to get the value of the boat, but they won't be able to get you personally because you had nothing to do with anything. It's just that you happen to own the LLC, but they won't be able to get at you personally. And it's the same thing with a plane or a car or a jet ski. So if you're causing the accident, then you're going to get sued. If you own the asset, you're going to get sued. If an LLC owns the asset and you're not involved at all, then in theory, they shouldn't be able to get anything against you. It doesn't mean somebody's not going to try to file suit against you. It'll just be up to your attorney to get you out of that situation. Now, let me talk about cars for a moment, because everything I said just now stands for cars. We don't generally put cars inside an LLC if it's your primary vehicle, because you're driving it, you're going to be liable for anything anyway. The only time you might see cars inside of an LLC is when the car has such a high intrinsic value. So if it's a Ferrari or a Lamborghini or a Rolls Royce, then the car becomes actually not just a liability issue for you, but it's also an asset that a creditor can get. So if it's just you're driving, a $50,000, $60,000 car, then it's your car. Just keep it inside keep it in your name, because anybody who gets hurt is going to sue you anyway. But if you've got a car that's also a high-end asset, that if somebody sues you for something else, they can get the car, then you might want to consider putting it in an LLC. It does have ramifications as to the insurance. It could be very costly. You have to shop around to get insurance on the cars if you're putting them in an LLC. So again, cost-benefit analysis. If you are an operating company and your company owns vehicles, then it's a different story. Then you might want to use the LLC not just for the protection from liability that the company might have if somebody gets hurt, but it's a way of separating out that asset from the operating company's books. So if I'm running an operating company and somebody sues my operating company, they can get a judgment against the company and get the company's assets. So if I instead do divisions and put some of the company's assets in separate LLCs, I'm really just bifurcating the assets of the company and making it very hard for a creditor of the company to be able to get at those assets. So that's what we might do with vehicles, with equipment, with machinery, even inventory sometimes. We break out the operating company. So it's not just how is the operating company owned, it's what does the operating company own. So it's an opportunity to basically make that company not a really good target because it doesn't really own anything. It's just leasing the ability or licensing the ability to use assets from other LLCs. So who should own the LLC? Well, the first question we always have to ask is it going to be a single member LLC with one owner, or is it going to be a multi-member LLC with more than one owner? Before I go into the ins and outs of this, I just want you to understand that we take a conservative approach and we look at husband and wife as a single owner. Others take a more progressive approach and see husband and wife as a multi-owner. CPA also has something to do with that and how they file the tax return. So for our discussion purposes, let's consider husband and wife as single owner. So let's say you have an LLC with one owner. Well, the good news about that is it doesn't necessarily have to file a tax return because it's going to be passed through unless you elect to treat it as an S Corp. So that's good. The problem you have is that there are some jurisdictions where it is clear in the face of the law and in case law that a single owner LLC does not entitle the owner to what we call charging order protection. Charging order protection is a remedy that a creditor has, charging order, where they can pursue a member's membership interest. So they can not pursue the membership interest, they can pursue the distributions that a member would receive from an LLC. So if an LLC decides to distribute out money at the end of the year and a creditor has a charging order against one of the members, then the creditor, if the distribution is made, the creditor stands in the member's shoes and takes the distribution. The good news is that the operating agreement can build in protections and not require distributions to be made, but we'll get to that in a moment. So if I'm the single member owner of an LLC and I'm in a state where charging order is the exclusive remedy of a creditor where LLCs are concerned, then I'm in good shape because my creditor cannot take anything from me. He can't take my interest in the company. He can't even look at the books of the company. The only thing he can get is if the LLC makes a distribution, the creditor can take my distribution. But generally, if it's a single member LLC, I'm in charge anyway, and guess what? I'm not going to issue a distribution. So if the charging order is the exclusive remedy of the creditor in that jurisdiction, you're in great shape. So states like Delaware, it's still the exclusive remedy. There are other states where it's the exclusive remedy. Many states allow for additional remedies, including foreclosure, which means that a creditor can foreclose on your interest and take over your ownership. So when we talk about choosing a jurisdiction, that will be one of the factors. So if you're in a jurisdiction where charging order is the exclusive remedy and the single members are have the same protection as multi-members, you're in great shape. But suppose you're in a jurisdiction like Florida, who the law was not really so clear until they had a case called the Barber case, where it was definitively stated and then memorialized in an amendment to the statute that a single member LLC does not afford charging order protection, but a multi-member LLC does. So if you're in Florida and your LLC is a Florida LLC and you have a multi-member LLC and you personally get sued, the charging order will apply and the creditor would only be entitled to distributions if they were made. However, it's clear as a bell. If it's a single, individually owned LLC, the creditor can actually break through and take your interest and foreclose on it. So when you're setting up an LLC, you need to look at the jurisdiction to see, is there any substantiation as to whether or not you do a single versus a multi-member. Not every state is clear, so if it's not clear, you want to assume that it is not an exclusive remedy. And if you have a single member now, then what you would do is explore the idea of adding somebody on. And we can talk, if you're further interested in this, we can talk further about it. And, what does it mean? How much of an interest do they need? Do they need to be involved? What are their positives and negatives of being an additional owner? I touched upon this a little earlier. There's something called a PLLC. It's a professional LLC. Not every state has one. It's only available for certain licensed professions. And the way it works is everyone who is a member of this type of LLC has to be licensed in that profession. So for instance, in Florida, you can do a PLLC for lawyers. You can do it for doctors. You can do it for accountants. As long as each person who is an owner is also licensed and there's a specific purpose, which is a professional purpose that's listed on the Articles of Organization and is okay with your state licensing board, then you're good to go. It's really just the same thing as an LLC. It's just it differentiates you a little bit in the fact that it's a professional LLC. So how do you form this LLC? Well, it always starts with a filing. After you've determined what jurisdiction you're going to do, it's either going to be what we call Articles of Organization or something called a Certificate of Formation. They basically all have the same information in it. It says what the name of the company is. You can put in an effective date if you want. Otherwise, it'll be the date it's actually filed. It states who the registered agent is, which is who's going to receive the complaint if one is filed against you. And if you don't live in that state where you set up the LLC, you have to find somebody else to be the registered agent. It's generally a company that you hire who will then send you the complaint once it's been delivered. It might list the managers. It might list the members. When we have a choice, we always like to go with a state that doesn't list the members online because there's no reason to give any additional information to the general public if you don't have to. Depending on what the purpose of the LLC is for is where you're going to file your LLC. So sometimes we don't really have an option. For instance, if a client has a piece of property and it's in Alaska and they're going to set up an LLC, it's going to be an Alaska LLC. And in Alaska, we list the members. In Florida, you don't need to list the members. Now, I've seen many an LLC set up by private citizens who don't go to a lawyer, don't go to a company that specializes in this. And believe it or not, with the very few pieces of information that you have to put, they don't always do it right. So there's no reason, for instance, I'll use Florida as an example, to list the members on a Florida LLC. In fact, there was so much confusion with having member managed LLCs that Florida doesn't even have that anymore. It's either manager managed or you can list the authorized member. To me, if you're listing the authorized member, then you're giving more information that's necessary. You're better off just making a manager managed entity and listing the managers. If you want to even be more private, then you can go a step further and create an LLC in a jurisdiction where nobody can figure out who owns it and list that LLC as the manager of your Florida or whatever other state entity so that even the individual managers' names aren't listed. That's an extra step not everybody wants to take or needs to take, but it is an available step. And we often use that in states where the members are listed. So we might set up a holding company to be the member instead of an individual member, so that we don't ever see a human being's name listed as an owner of a company. So that's member managed versus manager managed. When you have manager managed, you don't have to be a member to be a manager, which means you have more flexibility from an operating standpoint if it's an operating business. We can employ somebody to be the manager, and no one's really going to know who owns the company. So those are the things you need to do in order to file the LLC. Some states have some sort of subsequent filing that you need to do within a certain period of time, like California, which has a lovely $800 a year fee that they get you for. So you have to file that within, I think it's 3 or 4 months of filing the LLC, and then every year thereafter. So you have to be wary of what the filing requirements are for each state. Some states, when you form the company, actually have a publication element to it. For instance, New York, depending on what county the LLC is going to operate in, is how much it's going to cost you to publish in the newspaper that the LLC has been formed to the general public. I can tell you that if you're in Manhattan County in the city, it's somewhere around $1,250 or $1,300 to publish. Whereas if you're in like Westchester or Dutchess County, it's a few $100s. So it's going to depend where you're operating your business. It can make a very big difference. After the company is formed, we're going to get a tax ID for it through the IRS so that the company can open a bank account. And then lastly, we're going to prepare the agreement, the operating agreement. I can tell you that most people who do an LLC on their own don't even have an operating agreement. And if they do, and it hasn't been done by an attorney, they have something from one of those corporate formation companies, and it's usually pretty basic and not very good. It's something, but it's not usually enough. So what you want to do is you want to create a really good operating agreement. The great part about the operating agreement is as long as the terms are not contrary to the state law, you can really put anything you want in there, and it creates a tremendous amount of flexibility. So to me, that's really the most important thing with regard to an LLC is a properly drafted operating agreement. You should have clauses in there that protect the owners, the members, the managers, and the company from creditors. So there should be good clauses in there about how membership interests can be transferred and who can be an owner, so that if you are in a jurisdiction where foreclosure on a membership interest is allowed, well, there can be some prevention based on the operating agreement with that creditor being able to vote any of the interest that they actually end up foreclosing on. So there's a lot of things that you can put in there. You can put in that the managers have the right to dictate whether or not there's going to be distributions. So if a creditor manages to get themselves in there, distributions don't have to be made, with the hope of freezing the creditor out. So hopefully the creditor will be willing to sell out their interest for pennies on the dollar. So there's a lot of clauses you can put in that are protective clauses. We don't want the creditors to be actual members. We make them assignees. So it's a different level of ownership, so they can't vote. And you don't want them voting, because if they're voting and they foreclosed on the majority interest, then presumably they're able to replace the manager and run the company and make distributions. So you have to be very careful with that. The operating agreement needs to dictate who runs the company. Is it the members? Is it the managers? So we generally advocate for manager managed. Some clients want a little bit more member participation. So what we can sometimes do is we'll carve out certain things that require member approval. It's usually for major loans or for sale of all of the assets or for certain things that they feel should be member controlled, even if they're just appointing one or two of the members as managers. Another very important aspect of the operating agreement is how are you allowed to transfer your membership interest, or even are you allowed to transfer your membership interest? You always want to build something in there with regard for some flexibility for estate planning. So you can put in that a member is permitted without consent of the other members to transfer their interest into a revocable trust, or potentially into an irrevocable trust, or maybe to transfer their interest into a company, another entity of which they are the principal owner of or principal beneficiary of. So you want to build in some flexibility so that you don't have to go through a lot of hoops in order to transfer your interest if you're pretty much the majority owner of the company. So you want to make things a little simple for yourself, but you also want to keep in the asset protection of it where it can't just willy-nilly be transferred to anyone. And you don't want somebody to be able to transfer to a spouse or have it subject to a divorce in most cases. So sometimes we write that in. And you also want to make sure that you're dealing with how money is to be distributed. Who's in charge? Is the money distributed pro rata to the different owners? Can the money be added to your capital account instead of being distributed? There's a lot of different options that you can have with regard to distributions. And when they build the operating agreement, you want to put that in there. Who's going to be the tax matters partner? Who is the IRS going to speak with regarding the company? You can divide out the jobs within the LLC. If, for instance, it's an operating company, you can allocate certain jobs to the different members, or you can segregate out that the manager does X and this manager does Y. There's so much you could do because you build the agreement. As long as it's not against state law, you have tremendous amount of flexibility. And I will tell you, if you've ever been sued, you would know this. If you're ever up against a judgment and creditor is pursuing you, the first thing they're going to do is send you interrogatories asking for documentation and information, and they're going to sit you down for a deposition, and you're going to need to produce paper, and you're going to want to produce paper. The more paper you have, the more authentic things are for you, and the more you tangle up your creditor and make them spend more money because their attorneys have to review everything. So that operating agreement is extremely key to the whole process. Most times you're going to see that the duration of the LLC is perpetual, which means it doesn't have an end date. Rarely, a lot of the old ones I've seen, 20 years old, 15 years old, they have a term on them, which people don't even remember that they ever did. And then all of a sudden, when I'm reviewing an agreement, I see, oops, the LLC actually expires in a few years. And then decisions have to be made. They may have to liquidate. So generally, we go with perpetual because the members can always dissolve the company at an earlier date if they decide to. And then not every state requires you to put the duration on, and some of them that have a default to perpetual unless you put on a different time frame. At the end of the operating agreement is where we put the list of the members and the managers, or if you were doing a member managed LLC, you would list who the managing members are. It's important that that agreement be signed. I can't tell you how many operating agreements I've been shown by clients where they send me the unsigned operating agreement. I have no clue whether that operating agreement is in effect because it's not signed. So it's very important that it be signed. I don't care if you have to get it signed in multiple copies, meaning if there's 4 people supposed to sign on one page, each one, you send it, they each sign their portion, and now you have 4 signature pages. That's fine as long as you have signature pages. You can have copies. It doesn't have to be an original, although it's a good idea to have an original. If all of you are ever together in one place, do an original, but copies are also fine. I would prefer, instead of doing multiple signature pages, if one signs, sends it to the next, they sign, send it to the next, because otherwise the agreement becomes too long, something's going to get lost, and it's complicated for anyone who's trying to decipher it. So preferably everyone somehow signs on one sheet. It just makes life a lot easier. And lastly, with regard to the operating agreement is voting rights. You can determine which members have voting rights and which don't. Generally, what you're going to do is you're going to segregate that out with, if you're going to do differences in voting rights, you may segregate that out with doing Class A and Class B units, just like you can do in a corporation. So if that's something that you're interested in, that is a possibility, and you can build the operating agreement accordingly. And that we can use that sometimes if you have like an older generation, you give them the voting rights, but you give the majority of the ownership, the membership interest to the younger generation. It's a way of building equity and getting appreciation outside of the parents, who are generally the more wealthy of the family. How do you choose the jurisdiction for an LLC? Well, you have to look at what your goals are. So is your goal that you don't want anyone to know that you own it by being able to do a public search? Well, then you're looking for privacy, and we have to go in a jurisdiction that doesn't show much. So for instance, I'd like to use Delaware as an example. In Delaware, if I look up the name of a company, all I'm going to see is the name of the company, the date it was formed, and who the registered agent is. And the registered agent is generally a corporate registered agent, some big company that acts as registered agent. So you're really going to know nothing. And you can't really even, I don't even think you can, other than under a subpoena, I don't think you can even find anything further out, with the exception of you can pay a little fee and get a printout that says that the company is in good standing, meaning it's paid all of its franchise tax fees every year. So you might want to look for privacy. Another thing you want to look at is, what are the charging order, what are the creditor remedies in that state? Is it a charging order exclusive state, or is it non-exclusive, meaning they allow foreclosure? Is it a single member charging order exclusive? Is it only multi-member? Those are the things you want to look at. What are the state laws for LLCs? Again, using Delaware or Wyoming or South Dakota or Nevada. They all have very good LLC laws, which are debtor friendly, and therefore those are good jurisdictions. So those are great if you have full flexibility. What happens if it's an operating business, or if it's for a piece of property like real estate? Well, in that case, you may be limited in what state you can use. You may have to use the state that it's operating in, or that the property is located in, which may not be the best asset protection state, which is why you have the backup of making it a multi-owner, having a phenomenal operating agreement with the best clauses, with the most advantages, taking as much advantage of the state statute as possible. So you may not always have the flexibility, in which case you have to work with the cards you're dealt, and then you manipulate as much as legally possible in order to take advantage of whatever you can. So you want to look at state law is very important, but again, sometimes you really just don't have options. In some jurisdictions, they dictate as to whether or not members can easily be admitted into the company, or can you terminate a member's interest. That's something you definitely want to look at, and that's also addressed inside the operating agreement. And you're going to look at what managers are allowed to do under state law. So those are all the things you're going to want to look at. And then finally, of course, you're going to come down to cost. How much does it cost to set up? How much does it cost to maintain? Well, let me throw California out there again. I can set up a California entity. The actual filing cost is $70. Well, that's great. If I need a registered agent in California, well, now I'm going to pay a registered agent probably somewhere between $100 and $200 a year. But California charges $800 minimum a year for an LLC. So that's a low cost to start it, but a high cost to maintain. Other states have a high cost to create, but they may have a lower cost to maintain. So you're going to have to do if you have flexibility, you want to do a cost benefit analysis. And that's going to help determine what state you're going to use. But don't just jump on creating an LLC in your state, because it may not be necessary to create it there and it may not be your best choice. How do you dissolve it? I'm going to have to speed up a bit. How do you dissolve the LLC? Well, generally, it's dictated by what is said inside the operating agreement. It generally requires all members to consent. Sometimes it's just a majority, but it could require a unanimous decision. Same thing is, how do you disassociate a member, meaning how do you get rid of a member? That's very important to include inside the operating agreement, because sometimes a member is not doing what they're supposed to do, or they're creating some sort of bad situation for the company itself. Maybe they've done something immoral or illegal, or they declare bankruptcy. The LLC wants to step away from that as much as possible. So you're going to want to have mechanism inside your operating agreement to get rid of a member. And we already talked about the dissolution date. It's generally perpetual. It doesn't have to be. We can make dissolution voluntary or mandatory. And then finally, if there's a liquidation of the LLC, what happens upon liquidation? Who gets the assets upon liquidation? It'll say so in the LLC. Just for a moment, I'm going to throw this out there. LLCs don't have to be done inside the United States. They can be done outside the United States. If it's something you're interested in hearing about further, I'd love to talk to you about it. You can set up a complimentary preliminary consultation to talk about it further, because there are international opportunities that are perfectly legal and ethical if they are done right through the right sources. And as long as everything is done completely with the full knowledge of the IRS and all requirements are complied with. So it's not as private as it used to be, because the United States has imposed what they call FATCA, which is the requirement of other countries to report US-based holdings, meaning if an LLC is owned by a US taxpayer, then the other countries have to report it to the US. So you're not hiding anything, which is, in my opinion, actually not a bad thing, because this puts people in a much better knowledgeable position that they absolutely must comply with all IRS rules when they set something up outside the United States. And they're not going into it thinking that they don't have to do that. So it's an imposition. The other countries don't really like it, and it's making it more difficult to set things up and more difficult to get bank accounts open with small amounts of money. But if everything is aligned properly, then there's no reason not to legitimately be able to create an international LLC if it's something that works for you or your business. And lastly, we talked about how to own the LLC, that it could be multi-member, single member. There are different ways to own the LLC. It could be layered with another entity on top of it. And ultimately, it can be part of, or should be part of, your estate plan. So if you have a revocable trust, your LLC should either be directly or indirectly owned by your revocable trust. Or another option, if you live in a state where they recognize what we call tenants by the entireties for spouses, so a married couple might own an interest in an LLC in such a way that it's protected from their individual creditors and that it passes by survivorship. Okay. If you have any questions, please email them in, because unfortunately we've run out of time. I want to thank everybody for joining us today, and we will have our next webinar is next month. I'm not sure what the date is on that, but if you're on our newsletter, you'll be receiving notification on that with the opportunity to register. If you are interested in having the Presser Law Firm do a speaking engagement for you, please let us know, or maybe a webinar. Sign up for our weekly newsletter if you're not already receiving it, and we're always happy to send you complimentary copies of our managing partner, Mr. Presser's books, and to set up a complimentary preliminary consultation for you. So thank you again for joining us, and have a great rest of the day.